drinking water. Over 45 years in crime and not a conviction against him. Stephen Pallaras has been on the right side of the law and served in Australia and Hong Kong, Vanuatu in distinguished and sometimes challenging appointments. For 10 years, he was the senior Crown Counsel in the Attorney General's chambers in Hong Kong, where for several years he was the head of the International Extradition Unit in Hong Kong, working with senior government officials in countries around the world. Appointed by the State of South Australia as the Director of Public Prosecutions and by the State of Western Australia as the Acting Director of Public Prosecutions, where perhaps the greatest challenges were dealing with the political masters. He has sat as a Justice of the High Court and the Court of Appeal in the Solomon Islands at a time of significant conflict in the country, focusing on human rights and domestic violence issues, and addressing jurists and parliamentarians in New Zealand, Fiji, the Solomon Islands and the Marshall Islands. All of these experiences provide us with a privileged opportunity to hear from Stephen and his adventures throughout his career. Would you please join me in welcoming Justice Stephen Pallaras QC.
Thank you, Kevin. Is it safe if I close this?
Yes.
I can manage to stuff up anything that's got an electric cord plug into it. Thank you very much for the invitation to come and speak to you. It's a delight to be here. And given the manner in which the last speaker was told that enough was enough, I better hurry up and get on with it. Just a confession to begin with. I didn't know that Cinderella or The Little Mermaid or The Princess and the Pea or Thumbelina were all written by a Danish author by the name of Hans Christian Andersen. What I did know was that that same author wrote a story about the emperor's new clothes. And for those of you who don't know it or have forgotten it, it's about a king, or an emperor rather, who was so vain that he got his tailors to build him a new suit every day of the week. And the tailors, as you would expect, got a bit jack of that. And they came up with the idea that they were going to make this cloth and take this cloth and make a suit that would be invisible. What they in fact did was nothing at all. They said to the king, said to the emperor, only those who are worthy of their position in your court will be able to see this material. So the king, to be sure, I keep calling him a king, the emperor, to be sure, sent his courtiers to the tailors to check. And of course, they were dead frightened not to be able to see it because it would mean that they were not worthy of their position. So they came back and gave glowing reports to the emperor. And finally the emperor was satisfied. He said, right, it's time to wear this new suit. And he duly then paraded through the town in his new suit. Of course, he was naked. Now, the point of that, in one sense, is that the illusion depends at least in part on self-deception of those who are being deceived. And the story describes a scenario in which the people of his country were too frightened to say anything because they believed, and it was the perceived wisdom of the masses, that a person or a thing was good. Even the most obvious naked truth could be denied. And hello, Mr. Trump. Now, the emperor and his courtiers pretended that they could see this magnificent suit because they didn't want to appear as foolish, and turned out that in the end they looked more so. Now, the system of clothes that I want to talk to you about today is our legal system, a system that has been around for hundreds of years and regrettably has done very little to move with the times. The courtiers in this story, those who nod appreciatively at the fine set of clothes, are the legal profession. With apologies to any lawyers present in the room, I'm not talking about you. But frightened to criticise and happy to engage in self-deception for as long as the fees are paid, we have much to answer for as a profession and much to answer for in the manner in which we conduct our legal system. It was inherited, as we know, from Great Britain. It transplanted into our country a couple of 100 years ago, and the legal system that we now have is too complex, is too slow, is too expensive, is too unreliable. It does not serve the community well, and in particular is grossly unfair to women. Furthermore, our legal system, despite what many think, is not designed to find the truth. Let's start with a jury, and I want to pick out a couple of features of our legal system and make some remarks about them. Our jury system. The jury, a collection of 12 non-lawyers who are variously mystified, amused or bored with what's going on in front of them in court. When it was first developed in England, the system of jury determination, the jury were picked on the basis that they knew the accused, and the rationale was that knowing the accused man, they could then have a better understanding of whether it is likely that he did what he was accused of doing. Today, of course, any juror who has any knowledge of the accused is immediately disqualified from sitting on that jury. The role of the jury, too, is an interesting concept. At the beginning of every criminal trial, and for those of you who've sat on juries in a criminal trial, you will recognise the standard lecture that is given to jurors. And it goes something like this. Members of the jury, I am the judge in this trial. I will tell you what the law is. Do not be concerned with the law. Your function and your job is to determine the facts. And the facts are what you hear in this courtroom, not what you read in the papers or see on TV or go to the internet. They are told several times that their job is to find facts. They are told also that at the end of the evidence, they will need to return a verdict which must be unanimous and which, if they find guilt, must be beyond a reasonable doubt. Now let's have a look at those couple of propositions. And they are instructions that have been given to thousands of juries in our history and are probably happening today. If the prime function of the jury is to find facts, you might expect that they would be asked to tell us what facts they find. But you might also be surprised and even astonished to know that we never know what facts a jury finds. Why? Because no one asks them. They are never required to indicate what facts they have found as proven. And when they go into court to deliver their verdict, and the foreman stands up or forelady stands up and delivers the verdict, the jury, he or she on the jury's behalf says only two words, either guilty or not guilty. In other words, they return a verdict of law, which is what I suggest is a finding of guilt or innocence is. We never know what version of the facts they have come to in determining that verdict because, as I said, they're not asked. So in thousands of criminal trials, the jury are instructed to do something by the trial judge which no one ever knows whether they've done it or not. Next, guilt beyond reasonable doubt, a phrase that we're all familiar with and trips off the tongues of most criminal lawyers. What is it? Can I ask, this is audience participation time, does anybody have a view as to what beyond reasonable doubt means? What does it mean to you? Anybody? Sir?
Absolute certainty.
Absolute certainty. Anyone else? What about from the Scottish table that I've just learned? So what does beyond reasonable doubt mean? It means guilty. You can't get to guilty until you know what beyond reasonable doubt means. Anybody else have a view on what beyond reasonable doubt means?
Sir, beyond the doubt of a reasonable person.
The doubt of a reasonable person. I'll stop there because I think we've already demonstrated that if we can't agree on what the phrase beyond reasonable doubt means, even amongst ourselves, and I've only asked a couple of people here, how can we ever be satisfied that juror number 3's view of beyond reasonable doubt is the same as juror number 4's, or 5, or 6, or 7, 8, 9, 10, 11, or 12? So from that position, how can we be satisfied that they have found guilt based on the same criteria? So our jury might be told that they consider the facts, and only the facts, but never has to find any. In reaching a verdict of guilty, they may have come to that view by 12 different pathways. And in fact, the jury doesn't make a finding of fact at all in its verdict, it makes a finding of law. Now, I've done hundreds of criminal trials, either as a defence counsel or as a prosecutor or indeed... And I can tell you this, in at least 80% of the criminal trials that I've done in which a jury is involved, within an hour of them being sent out to deliberate their verdict, you get a knock on the door, they want to come back into the court. And they come back into the court and they ask the judge a question. And inevitably, the judge, the foreman, stands up and says, Your Honour, can you give us some guidance on what beyond reasonable doubt means? Now, that's a reasonable question, but what the judge has to say is not reasonable, because he then says, thank you for your question, no, I can't. And you ask yourself, well, why not? And the reason is the appeal courts have come down very heavily on trial judges who have made up a definition of beyond reasonable doubt which the appeal court doesn't agree with. So rather than have that happen every time, the appeal courts have told judges at first instance, do not elaborate on the concept of beyond reasonable doubt. Simply tell the jury, and this is what judges inevitably do, no, I can't help you, but just use your common sense. Now that raises all sorts of other questions. Who's common? And have they got any sense? And how do you go when you've got 12 people who say that they want to use their common sense? So I'm unhappy with the jury system. Let me go on to parole. Our accused is given a 10-year sentence, let's say, with a non-parole period of 6 years. And what that means is that if he behaves himself for 6 years, he'll usually be given release by the parole board, and out he goes 4 years short of the end of his sentence. Why? Now, I assume that most of us here, and you don't have to tell me if you're not, but most of us here have been law-abiding today. Has anyone got a phone call from the government to reward you for being law-abiding citizens? What about yesterday? The day before that? Ever? Then this prisoner who sits in his jail, given a penalty of 10 years, who behaves himself, has done nothing other than obey the law. That's all he's done. That's what we've done. He, however, gets nearly half of his sentence off. And I ask, why? Remember, in giving the initial sentence, and I'm taking 10 years as an example, that was arrived at by an experienced criminal lawyer, a judge, who has seen many such cases and can put this one in perspective to the rest of them. And they make an assessment before coming to a figure as to the criminality, the seriousness, if you will, of the offence. And this judge has thought that this case deserved 10 years. It was in the serious category. none of whom are lawyers, and say, well, after 6 years, you can go out. Now, you may ask yourself, why do the... I know the head of the parole board, she is very strong in advancing the argument that the reason is to encourage prisoners to behave themselves in jail, so that they don't get there, try and whack the water over the head, or they don't get the knife and shove it into their cellmate's side. But you know what would achieve that far better? If you're sentenced to 10 years jail, then you do... and if you've behaved yourself, you will get out in 10 years. If you haven't behaved yourself, then what we'll do to reward you for that is tack on a bit until you've paid for the offence of whatever it is that you've committed while you were supposed to be obeying the law. Now, in the last prison riots in South Australia, I think they were in the 80s, before my family came here, there was an investigation as to the causes of the prisoner dissatisfaction. And the main cause that the prisoners expressed for the reason for their dissatisfaction was that they were never sure of what date they would be released, because even though they may have had a non-parole period, all that meant was that they could go before the parole board and make application to be released, but they were never sure whether they would get it. And so their beef was, even if we've got a non-parole period, we don't know whether we'll be parole. We want to know for certain when we're going home or when we're getting out of here. A reasonable beef, you might think. So the problem, I think, could be totally removed and totally solved if a prisoner knows that if he behaves, he will get out at the end of the sentence. And if a prisoner knows that if he misbehaves, he won't. Problem solved. So the figures for recidivism don't give anyone, I think, any confidence that this parole system is actually helping lower the crime rate. I don't say that it's actually increasing it, but we're releasing people into custody, from custody, who have yet to serve the sentence that a trial judge considered as appropriate. And I think that's wrong. In the next episode of these ramblings, I'd like to talk about how the legal system actively prevents women, particularly in sexual assault cases, from ever achieving justice. It is a system that is rigged against females. It is a system that usually one word against the other. Now, if a woman gets up and says in a reasonable, believable way, that man raped me, and a man gets up and says in a reasonable, believable way, no, I didn't, is a reasonable doubt, which is the explanation for why our rape figures, conviction figures, are so abysmally low. Because it simply takes, and you rarely have a witness in a rape case other than the accused and the alleged victim. And when it's word against word, it's very hard to convict anyone, and very hard to convince a jury that they should reject one word, although reasonable, and accept the other. And inevitably, they come back with an acquittal. The other ways that the legal system treats women are renowned, and the case of Brittany Higgins just recently, I think, is something that we all should feel aghast at. That what it does to women who go through the system, it totally destroys them. very few ever recover. I won't go into any more of that topic now, and if you'd like to hear more, you'll have to invite me back again. But as a think of every woman that you've ever loved. Think of every woman that you've ever known. Think of every woman that you've ever seen. And think of every woman that you've ever heard of. If they are in Australia, more than half of them have been sexually harassed or offended against. That is the ghastly truth of sex offending in Australia. From television, to personalities, to entertainment, from sports to the workplace, to the highest office in the free world, hello again Mr. Trump, this conduct seems to have become the norm. And what does our hallowed legal system do about it? Well, you'll have to invite me back, as I say, and I'll tell you. I'd be happy to take any questions. Sir.
You were talking about the jail system. How many more jails do you think would be needed to house those who are under your plan?
I don't know the answer to that, but if it's a question of economics, let's make it a question of economics. Let's not pretend that we are somehow being kind to the community or to the prisoner by giving him a parole period. If it requires more finances, then most of you will recall in the last election campaign, the then government was talking about $300 million. I think it was the last figure, building basketball courts. Well, you could use some of that money, I would have thought, to build another. I'm not in favour of prisons. Certainly in some cases there is no alternative that we've yet devised. And I'm not in favour of locking people up just for fun. I'm not. But I'm also not in favour of giving those people who have offended and have been convicted by a jury, beyond reasonable doubt, whatever that means, of letting them out without due punishment. I think there's room for both. Yes, ma'am.
It's great talk, thank you.
Thank you.
Now that you're not in a court right now, what is your definition of reasonable doubt?
I should have seen that one coming, shouldn't I? Let me say this. There are other jurisdictions across the planet that use different standards of proof. They raise from the bottom reasonable suspicion. If you have a reasonable suspicion that the case is proven, then you can convict. The next one up is the American case of probable cause. If there's probable cause here that you've established in the evidence, facts and circumstances that lead an ordinary person to believe that the accused is convicted, that's also a standard of proof. There's another one called the preponderance of the evidence. So if you're looking and weighing up the evidence for and against, if the preponderance of the evidence is such that it leads to one verdict, then you return that. Next is clear and convincing evidence, which is a firm belief or a conviction. It speaks of the individual's belief and conviction. And then there's beyond reasonable doubt, which is the top of the list. I don't think we need to go to the top of the list if we're going to get results that are A, fair, and B, predictable. It's no point having a legal system that people are asked to use when they have issues if they go in knowing they're going to lose their house, or they go in not knowing whether they've got a snowflake's chance in hell of winning. It doesn't serve the community well to have such a lottery system. My view of beyond reasonable doubt is just as valid or invalid as everybody else's, because it's such an indefinite concept. You can't tick off the elements of beyond reasonable doubt, I don't think, because reasonable itself is a qualitative term. What's reasonable to everybody, I might think, is unreasonable. So I won't make the argument any worse by trying to give another definition. I'll just say that that's not the only way we can deal with doubt.
Thank you. I thought that was a very, very interesting and honest address from a senior jurist. Two questions. Firstly, in relation to the more recent emergence of criminal and civil damages, I just wanted to comment a bit on that. The other one, getting back to your comment that parole concept is leading to people coming out of prison earlier. You may not wish to comment on this, but has there been any adjustment by the judges when giving their verdicts or setting their sentence, factoring into their decision that this guy really should have 10 years, but if I give him 10, he's going to get 6. So I'm going to give him 16, so he gets 10. Does that happen?
Let me take that part of your question first. If they're doing their job, no, it doesn't. Are they doing their job? It's a reasonable question. Yes, I do have some reasonable doubt sometimes, but look, I don't think that anyone who is properly trained in the law, who's reached the position of a judicial officer, would have the maliciousness to do something like that. Most of all, the sentences that are handed down by the trial courts, I find are certainly within limits. There's always the remedy of an appeal if the judge has gone overboard and given you 25 when it should have been 10. There's always that. So that's a safeguard, I suppose. But no, I don't think judges do that. The next question was civil and criminal injuries. It's an American practice that if you lose in the criminal courts, and I think again, hello, Mr. Trump, I might have missed a hello to him, then you can take your case for civil damages. It seems to me to be a second bite at the same cherry, but the difference is that in the civil case, you don't need to prove anything beyond reasonable doubt. The standard of proof in a civil case is much lower and usually revolves around the issue of damages, whereas in a criminal case, it's guilt or innocence. Is that a good thing? I don't see why not. I think the more opportunities there are to actually come to a decisive conclusion to something, whether it be civil or criminal, the better. There are some cases, some celebrated cases, I've forgotten which the name was now, but it might even be the case in Canberra where they're talking about the allegation of being raped in one of the politicians' room in the Parliament House, and then taking it out of the allegation, the criminal allegation, to a civil allegation of injury. I don't see that there's anything wrong with that. If there's going to be some ended against, I think that's fair. The only question that I have in my mind is whether you're getting two bites at the cherry. Might be an unfortunate choice of words there. But no, I think there's room for both, because there's different standards of proof, and because if one is banned from using one particular avenue, you can always use the other. And I think that's a good thing.
Last question. Regarding parole first, that's probably more of a statement. I thought always one part of one part of sentencing is punishment and the other one is rehabilitation. If you have rehabilitation, then why not basically take the parole part as the part of rehabilitation? However, my question is probably more provocative in terms of you want fair and predictable. Why don't we take all the judges, all the prosecutors out of sentencing? Outsource it to basically artificial intelligence. You get much fairer, much more predictable, much better prediction of recidivism. All of these kind of factors get put in. It doesn't matter if it's a man or a woman. It doesn't matter if you had your coffee in the morning, if your football club won on the weekend. All of these factors get wished away. We basically have a very clear, very predictable system of sentencing in the legal system.
Well, that wouldn't work for me because I follow Carlton. And I'd be in a bloody bad mood most of the time. So Look, I don't know. It's pretty formulaic what you're suggesting, and I think we need scope to introduce differences in cases. I mean, there are very two cases ever that are the same, very few. So although I understand the motivation in trying to get things organised, I don't know that that sort of formula will necessarily work. You might be right.
Stephen, I'd like to end with a quote that you actually made, saying that there are always another way to look at things, alternative solutions, differing interpretations, and I think it's very poignant for today's presentation. Thank you very much. Stephen, all monies raised from today go directly to our Rotary community and youth projects, and your presentation helps make this possible. May I give to you a certificate of appreciation and a bear that's not in the Carlton colours, as a gesture of thanks today. Rotarians and guests, please join me in thanking Stephen Pallaras.